Our next speaker is Yona Rozen, and then I guess we'll take one more, Brian Bixby and Carla Kozak before our break. Good afternoon.
Good afternoon. Thank you. Chairman Liebman and board members, sorry. I appreciate the opportunity to be here today to speak to you. My name is Yona Rozen. I am with the law firm of Gillespie, Rosen, and Watsky in Dallas, Texas. I have been there since the fall of 1983, representing primarily employees and local unions. Before that, I worked for the National Labor Relations Board for 3 years in the Buffalo Regional Office, and then for 2 years at headquarters in the Division of Advice. So I come to you, obviously, my perspective at this point is representing unions, but my practice, and I think I want to spend a minute saying this, is that I really believe in the power of unions and the opportunity for employees to find their voice and find a way to address issues at their workplace through unions, and that it's a much more effective way than the other people that I deal with and represent, who are individual employees who have legal issues that are addressed through private litigation and through employment arbitration. And I think the employees that I work with, the workers I work with who are represented by unions, have a much more satisfaction and much more success in dealing with workplace issues with their employers than do individuals who are put to the situation of having to proceed with a lawsuit, and even when they are successful, it's not a very satisfactory process. So for that reason, I come to speak in support of anything that can be done that will improve the process for employees to be able to vote to determine whether or not they wish to be represented by a labor organization. I think I've been rather surprised by the reaction to the proposed rules, because frankly I don't see them as being, in most respects, tremendously huge changes. I think they're fairly modest suggestions that will be effective in addressing some of the issues to some extent that are presently presented by the process. And so I come to speak in support of these rules, although I could also think of other things that might be done further. But I do want to speak in support of the rules, and I thought in doing that, the most effective way, I thought back over I've probably handled hundreds and hundreds of election petitions over the years in my various positions, and I thought of several that I wanted to focus on today that I think would have been helped by the process that's proposed in these rules. And when I say they're fairly modest, one of the things that struck me particularly about the proposals is that in many respects they are putting forth in more specifics things that are frequently done by the regions on a more of an informal basis, and also on a perhaps not across the board, because different regions have different practices. And so I will address those as I reach them. The two cases that I wanted to focus on particularly today, and how these proposed rules would have assisted in moving the process forward and in saving time and cost. The first one goes back to my very parting days of leaving Region 3 in Buffalo, when I was assigned, probably because I was no longer going to be on Tom Sealer's payroll, and so the time would not affect the region and would be stuck on advice, but I was assigned to be the hearing officer in a hearings on objections for a 13-person unit that overwhelmingly voted in Detroit to be represented by the Teamsters. The management then filed 113 objections to that election, none of which ultimately were upheld in my hearing officer's report and recommendation, and ultimately by the regional director. The process of I think informally a lot of regions do require some sense of what your objections are, what evidence you have to support your objections. But formalizing that would have greatly assisted in this in this particular case, because the quality of the objections in this case, for example, where there were 10 or 15 objections, there was a single person in this 13-person unit who was deaf. And many of a number of objections related to trying to sort of hop on the back of the failing to translate into Vietnamese or failing to translate into Spanish type objection, the failure to provide someone to translate into sign language, the pre-election conference, and the ballot. There was absolutely no evidence whatsoever that this individual could not read and understand everything that was presented in writing. And of course, the directions were presented in writing as well. So we had 2 separate periods of hearing, approximately 6 days to address this. I'll remember it very well because it was during the air traffic controller's strike. I had to get special permission to take a motor pool car across the border to drive to Detroit. The reason I was assigned from Buffalo for a hearing in Detroit was because there were allegations, again without any support and any substance, of board agent alleged misconduct. This is when I think back about that case, and the case dragged on forever, I actually eventually lost track of what happened in the case ultimately. But that was a case where having the requirement that is proposed, where not only are the objections filed, but the evidence and a proffer of proof as to what would be provided in support of those objections would be very helpful. Also, I think the fact that there not be an automatic right to review by the board would be helpful in that case. The second case that I wanted to address is a case that I was involved in much more recently, and I think it raises a lot of it would have been helped and assisted by a lot of the rules that are being proposed with respect to both pre-election hearings and also post-election. This was an election that occurred back in 2009. The petition was filed. It was for a 220-person unit representing Sears service techs and it's a very large unit. They worked out of several facilities. They were in a particular district in the Dallas, Oklahoma, Northern Texas region. It was very difficult to communicate with these. The campaign had gone on for over 2 years, addressing the issue of whether employers have an opportunity to understand and know that the campaign is going on. My clients, primarily consistent with what was stated by an earlier speaker, well in advance of filing a petition, send out notification of the organizing drive and notification of who specifically is on the organizing committee. Similarly, as to what was stated, to give protection to those who are coming forward and supporting the union. But the other impact of that is that clearly the employer is well aware long before the petition is filed. In this case, the employer knew for 2 years there was an ongoing campaign and was well aware, and is demonstrated from how they acted during the process. They had plenty of time to talk to their employees long before the petition was filed. As we come up on the hearing, I'm
going to ask you to try to start wrapping up.
I will, thank you, I'm sorry.
You're about 3 minutes over already.
Oh, I'm sorry,
yeah,
I didn't realize, I'm very sorry.
Yeah, that's okay.
I didn't know what that meant. In any case, the hearing was, we were going to agree to add 12 people to the unit, and at the very last minute, the evening before the hearing, the employer added 53 additional people from another location, from an entirely different district, clearly, and we ended up spending 2 days litigating that. And it was an example where if the employer had been required to put forth what their position was and to put forth the proffer of proof to support that, that could have been addressed. So thank you very much.
Thank you. Any questions?
Just one quick question about the first example that you mentioned, the objections case. Mm-hmm. How would the proposed rules change what the experience you had in that case? I mean, don't our rules and procedures currently require that objections be filed in a timely fashion and that they be accompanied by sufficient information to enable the region to determine whether or not a hearing should be held?
In the first place, yes, I think some regions have that procedure. It's less formal. That was my point in that I think some of these proposed rules are not really major changes, but are simply standardizing the process that is followed in some regions. So yes, I think, and I do think the more emphasis on you actually have to make a proffer of proof as to what evidence you're going to present to support these would be helpful in giving the region an opportunity to determine whether or not to proceed in that case, and also the fact that there would not be, under the new rules, there would not be of right appeal to the board in every case.
In your experience, having been involved with campaigns, have you also experienced your clients having to withdraw petitions?
Yes.
What circumstances would prompt the withdrawal of petitions in your experience?
Well, a number of circumstances. I mean, I've had circumstances where we had a lot of support initially, the campaign was going well, people get terminated, people get scared, the support is dissipating, and therefore the union would withdraw the petition.
Okay.
And I guess the other thing about that in the case that I was talking about, my clients, we had some pretty good objections, I thought, post-election in that case, the Sears case, and my clients asked me not to proceed with those once, to request review on those. They brought some interesting issues that I would have liked to have proceeded, but they preferred, rather than have the delay, to just start the time rolling so that they could go back in 12 months with another petition.
I see.
And they also lost a lot of support in the objections because people were scared.
Thank you.
Thank you very much for your
Thank you.
comments and
Thank
for
you for
being
your
here
time.
today with us. We'll take the next, is it one or two speakers? One.